In this video, we will provide you the quick recap on the weekly immigration updates happened right from President Biden, Congress, Senate to every U.S. agency, such as USCIS, Department of State, DHS, embassies and more.
Visit our Swat&Vee channel with your questions to see how best we can help you out your process. Please don't forget to subscribe if you're new to the channel.
Now let's get into the video and find out what's new in U.S. immigration. Number 1. H1-B Visa and big spike in H1B Visa salary. According to a recent report published by the United States Citizenship and Immigration Services, USCIS, an individual working in a position that requires an H1B work visa may expect to make an annual salary of approximately $130,000. Number 2. Supreme Court strikes down affirmative action in college admissions. The Supreme Court issued a decision that put an end to the practice of using affirmative action in college admissions. The decision stated that colleges and universities are no longer permitted to use race as a specific factor for admission. Chief Justice John Roberts penned the ruling on behalf of the conservative majority of the court, claiming that these programs did not have measurable aims to justify the use of race and that they reinforced racial stereotypes without a clear endpoint. He did so on behalf of the conservative majority. The ruling may also impact financial aid opportunities for international students. Affirmative action policies have been instrumental in promoting diversity and inclusivity, ensuring that students from marginalized backgrounds have access to financial aid programs. A potential shift away from these policies could limit the availability of financial resources, further exacerbating the financial burden faced by international students. Number 3. Canada announces new work permit for US H1B visa holders. An open work permit stream has been made available by Canada for H1B visa holders currently residing in the United States. Under the terms of the program, 10,000 Americans will be eligible to find employment in Canada, and the members of their families will be able to get visas to study or find employment. The open work visa grants its holders the ability to work in Canada for any employer of their choosing for a period of up to 3 years. Number 4. USCIS removes 60-day rule for civil surgeon signatures on Form I-693. U.S. Citizenship and Immigration Services has removed the requirement that civil surgeons sign Form I-693, Report of Immigration Medical Examination and Vaccination Record, no more than 60 days before an individual applies for an underlying immigration benefit, including Form I-485, application to register permanent residence or adjust status. The requirement had been subject to a temporary waiver since December 9, 2021. Civil surgeons no longer have to sign Form I-693 no more than 60 days before the underlying application for an immigration benefit is filed. Now USCIS will be able to accept these Forms I-693 for adjudicative purposes for up to 2 years after the date the civil surgeon signed the form. Number 5. At-risk youth can apply for green cards thanks to a new bill. Democrats in the House of Representatives have proposed a plan that would make the process of acquiring green cards for vulnerable youngsters who are at risk of deportation more straightforward. The Green Card for Kids Act is a piece of proposed legislation that would create a road to permanent residency for young people who have been abused, neglected, or abandoned. The law would be known as the Green Card for Kids Act. Number 6. USCIS issues guidance on analyzing employers' ability to pay wages. U.S. Citizenship and Immigration Services issued policies to analyze an employer's ability to pay the proffered wage for immigrant petitions in certain EB-1, EB-2 and EB-3 employment-based immigrant visa classifications. Employers seeking to classify prospective or current employees under the EB-1, EB-2, and EB-3 preference employment-based immigrant visa classifications that require a job offer must demonstrate their continuing ability to pay the proffered wage to the beneficiary as of the priority date of the immigrant petition. Number 7. Presidential Advisory Panel recommends extending H-1B grace period to 180 days. A presidential subcommittee on immigration has recommended the U.S. extend the grace period for laid-off foreign workers on H-1B visas from 60 days to 180 days. Currently, out-of-work H-1B visa holders have to either find a new job within 60 days or return to their home country. The advisory panel said current restrictions place extreme stress on laid-off workers and cause the U.S. to lose highly skilled talent. Number 8. Immigration barriers force U.S. companies to relocate foreign employees overseas. A growing number of U.S. companies are relocating foreign employees to another country or abroad to get around restrictive work visa policies, according to a new survey. Of the 504 companies that participated in the survey, 81% said they had transferred foreign employees to overseas offices, primarily in Canada, the UK, and Mexico. Employers cited the limited number of H1B work visas as the biggest barrier, followed by long processing times and complex government regulations and paperwork.
I hope you guys found this video extremely helpful. If you know anybody that could benefit from this information, definitely make sure to share this video with them. We are all about empowering you with knowledge. So the more people that can benefit from this video, the more people we want watching this video. If you like this video, please make sure to hit that thumbs icon. Thanks for watching, and don't forget to subscribe and hit on the notification bell for more immigration updates. Bye!